All right, now let's take you live to the media briefing by Chapter 9 bodies, civil society organizations and the legal partners on the progress being made regarding the upcoming case of Caster Semenya.
This press conference is just to, each and every one out there who's willing to help, for us, to fight, this case. As you all know that I advocate, for, human rights now. I don't want to talk more about sports, as, I've accomplished everything I wanted. But I think this is about humility. It's about building sports. It's about inclusivity and diverse. It's about, building young African women and, Asians. As we all know that I've been facing, the scrutiny, judgmental, criticism about my being. But I think this case is bigger than that. It's about, allowing young Asian, girls, young African girls, to partake in sports. We all know that, this case is all about, it's about, the differences in women's body. And the main goal is to make sure that we protect, we save, these young kids so they can be able to compete. I urge, each and everyone, to come on board, maybe cooperate. Whatever you have, just come help us, fight, this cause, so that can, those young, Africans and Asians that are affected by this, ruling, they can be able to, compete. As we know, the case comments in the high, European court, it's a high court, and they've appealed. We go in there in May. We lack funds. We have a lot of experts that, they come in, that, we need to pay, those fees. So anything that you may contribute, a huge difference. And I'm accompanied by, my legal team, people who represent me. They will unfold, more of what is needed. Your help will be highly appreciated. You all know that I'm a woman of less, words. My actions, they speak louder than words. My work now is just to advocate, for those who are silent. I have a word, they can't speak, but I can do that work for them. So if each and every one out there, can just come on board, we help these young kids who are affected. For me, I'll be fulfilled. So I can't say much. I'll just take this opportunity again to thank you for coming, for allowing us, to share, this word with you. I hope each and everyone out there who's watching, you may, read on the newspapers. I hope this means, something to you. For me, I would say it's a learning curve because we educate parents, everyone out there who does not have an idea of what we are going through, people who are born with differences. We face a lot of scrutiny. Some we have depression. Yes, we may not show it, but it affects our lives. It affects our people who are, around us, our families, our loved ones. But the little that you can give make a difference to those who are affected by this ruling. Thank you.
Good morning, everybody. I'm Patrick Bracher from Norton Rose Fulbright. I've been Caster's lawyer throughout the legal process from the beginning. I'd like to start by painting a scenario, and I'm going to talk from a position of the law profession, but whatever profession you're in, just imagine yourself in this position. Assume, and I hope this is not a difficult assumption, that I'm a world expert lawyer. Because I'm a world expert lawyer, fully trained, I get all the big banking work and all the big insurance work in South Africa. And the Legal Practices Council comes to me because I'm under their auspices and says, Patrick, you're getting all the work and there are other firms in town who are not getting enough work. I want you to do something about your abilities. You're a clever guy and you're getting the work. So what we'd like you to do is to take opioids morning and evening so that you can dull your intellect, because that will give the other lawyers the opportunity of getting the work that you've been enjoying. Now put yourself in that position, and that's exactly what has happened here. It's a tragic story, and it's gone through many, many rounds now where we've had the same battle. Let me start at the beginning. The original regulations were passed by World Athletics, and they affected all athletes from all types of disciplines. They were challenged in the Court of Arbitration for Sport, which is the only way to challenge a sports regulation, the only way in the world you can do it, because you sign up to that as an athlete. They were challenged in the Court of Arbitration for Sport, and that application, before Caster was involved, was successful. The Court of Arbitration for Sport said you just haven't got enough evidence for what you're trying to do to stop athletes running and competing in elite competitions. They then passed another set of regulations, and we call these the Caster regulations, because they were aimed particularly at runners between 800 meters and a mile, exactly the distances that Caster was best at. And they've had an obsession at World Athletics, I think, about Caster. The regulations were passed, and we then went to the Court of Arbitration for Sport and challenged those regulations using a team of Carlos Sauer and Jim Bunting in Canada, who had acted in the previous case, international sports law experts, and we challenged the regulations. Lots of evidence was led about genetic advantage and advantage. And as a panel of 3 persons, we lost 2-3. We know that they never published the minority opinion, but we know it was from the Canadian lawyer who was on the panel, and that lawyer was chosen by us. It's got this system where each we chose a Canadian lawyer for obvious reasons, because they have a constitution like ours. They understand human rights. They understand dignity, gender equality, understand everything. Our Constitution, our Bill of Rights is based on their Bill of Rights. Anyway, we lost we know that the other panelist was chosen by World Athletics, was a very conservative Swiss lawyer. And I'll come back to Switzerland as I go through this saga, because I don't think the state of Switzerland have given themselves credit for where we are today. So we lost. We know the chairperson was from Australia, and she subsequently made a speech saying that she was hovering between finding for us and against us, and swung in the other in favour of World Athletics. Now, that meant that we had to go on appeal to the Swiss Federal Court. Now, let me paint the picture where we are now. In the European Court, the case is known as Caster Semenya versus Switzerland. And if you take that in, you can see the imbalance of power when you're trying to get access to justice. And I'll come back to some of the implications of that. So Caster Semenya, who stood up for years now as the one person in the world to challenge these discriminatory regulations, the one person, and that's what I admire about Caster most of all. We use the word indomitable for her. And we went, now when you say you go to the Court of Arbitration for Sport, bear this in mind. World Athletics is based in Monaco, not a cheap place to visit, by the way. When I looked for human rights lawyers to help me in Monaco, I didn't get replies to my emails. Then you go to the Court of Arbitration for Sport. That's in Lausanne in Switzerland. It's no longer the case. A few years ago it was built to be one of the most expensive cities in the world. And now you Caster versus World Athletics, who made their money, by the way, partly with her running talents. So we go through that, and then your only recourse, because you are in Switzerland, is to the Swiss Federal Court. We went to the Swiss Federal Court, and it's all done on documents. To this day, I do not know what the 5 Swiss judges looked like. I know their names. I know the one is called Kiss. I said that's the kiss of death. But we got a judgment, and it's an interesting thing, because we didn't have a hearing. You don't get to address anybody, and when they've made up their mind, they send it to you in the post. Well, Swiss Post works a bit better than here, so we got it the next day, but it's all in French. Asked them for a translation, and we couldn't get one, so you go to Google Translate for a sort of judgment that affects her entire life and economic life and personal life. You can't get a judgment in your own language. And by the way, on that, quite ironically, last night arrived in my inbox an announcement from a Swiss lawyer saying they're introducing a new law from 1 January 2025, which will enable corporations who want a dispute bigger than 100,000 Swiss francs to go to the Swiss courts in English and get judgments in English. But you've got to be a corporation, you can't be an individual, you don't get the benefits of this new law even if it were in place. We lost in the Swiss Federal Court, and the important part to note in these courts is that I got affidavits from all over the world from human rights lawyers who've got bills of rights, like India, from England, from Europe, from South Africa, from the USA and Canada, to say that this would never be upheld in a proper system. World Athletics' case is that this has got nothing to do with international human rights. This is a contract. We signed up Caster Semenya as an elite athlete, or as an athlete, and you're bound by the contract. So don't throw the United Nations Convention on Human Rights at me, and don't throw the human rights at me, because this is a contract. And if I pass a rule by majority vote on my committee, then all athletes in the world are bound by that. So that's an important point that I'll also come back to. Now, in the Court of Arbitration for Sport, they didn't consider the affidavits and the information from the United Nations. We had support from the United Nations, support from World Medical Association. The human rights issues were said to be not very helpful, and they found on the facts. What they also said in the course of the Court of Arbitration for Sport judgment is that the World Athletics had a paucity of evidence about a genetic advantage of Caster and other athletes in that range of running. But despite the paucity of evidence, despite the paucity, they used the word scarcity as well, they still found against Caster. When you go to the Swiss Federal Court, it's a different issue, because the Swiss are very proud of their role as international commercial arbitration center. And their main thrust of their objection to the Human Rights Convention in Europe is the fact that it will interfere with their inner workings as an international human rights commercial arbitration center. And that although now with this new law, a company from South Africa with a dispute above 100,000 Swiss francs can go to Switzerland and have an arbitration, an individual, they say, shouldn't be allowed because you're opening floodgates to all sorts of people coming to get arbitration in Switzerland. Which is, of course, is nonsense, because the only reason we end up in Switzerland, not by our choice, but because the Court of Arbitration for Sport is there. And the Swiss Federal Court has said that they've got jurisdiction over the findings of the Court of Arbitration for Sport. So your access to justice at every level is not choice and is not free. Now, what happens then when you get a judgment in the Swiss Federal Court? The recourse is to the European Court of Human Rights, which is in Strasbourg in France. And it's a two-step process. We put in our case, and we got priority treatment. And the European Court of Human Rights deals with cases from all over Europe and all members of the European Union. And serious cases, people who've been detained without trial, assaulted, etc. Human rights issues which are very serious. But they took this case seriously, and we believe it's because it gives an opportunity to look at a very important issue, and that is, firstly, the issue that I mentioned is a contractual issue or a human rights issue. And secondly, is the access to justice in Switzerland open to an individual athlete or individual sportsperson? Let's put it more broadly than that. And those are the main issues. Now, Switzerland have put in a long submission to the court saying that it shouldn't be opened up. Now, let me tell you what you get in Switzerland. And the first time I spoke to a Swiss lawyer, and we had a very good Swiss lawyer, Doro Schramm, who's an arbitration expert. We phoned up and I said, well, what is the test in Switzerland? And they said, it's Swiss concepts of public policy. And if you try and pin that down, it's not the same as going to the Bill of Rights in South Africa, where you can read it and apply it. It's not the same as going to the European Convention. It's not the same as going to the United Nations Convention on Human Rights, because it's a concept of public policy. And within that, they take account of the European Convention. But what you don't get from the Swiss court, you don't get direct access to the rights under the European Convention. And that is where we are now. We went to the European Court, and that's a two-stage process. The first thing they do is refer it to a panel. And we succeeded in front of a panel by a majority who said two things. They said, if you're going to discriminate on the grounds of gender, you've got to have very compelling reasons to do so. And you haven't, and the Swiss court has not examined whether whether World Athletics had compelling reasons to do so. And that is the test that has to be applied. And secondly, about access to justice, the point I've been making. Here is an individual athlete who's told they can't get access to the European court via the Swiss court because it's an individual, and some floodgates will have athletes rushing for assistance in Switzerland. Now, the importance of what we're doing here is so important, and that is because of what we hope the outcome will be. If we get the outcome that we got in front of the panel, well, let me just explain. Once the panel has decided, the other party, the losing party, is entitled to refer it to the Grand Chamber. And if you remember on the televisions recently, the International Court of Justice received 15 judges, same sort of system. 15 judges in the Grand Chamber will now reassess what was done by the panel to see whether they will agree or disagree. And what we're hoping will happen in there is two things of massive importance. One is that if they find that for athletics bodies worldwide, and it's not World Athletics running and jumping athletics only, it's all sports, it's an International Olympic Committee, the swimming federations, all the things that you can think of will be affected by this judgment if they are based in Europe or when something goes through the Court of Arbitration for sport. It's massively important from that point of view if the European Court takes on and tells the Swiss court to take on human rights in their courts for individuals. And the other point that I made is that it's a discrimination case. If we can get that endorsed, that in order to discriminate on the grounds of gender, you've got to have very compelling grounds. I mean, that's what it should be. It would be here. It would be here. And so that is where we are now. We've got a hearing on the 15th of May in front of the Grand Chamber. We've been assisted by Shona Jolly, King's Counsel in London, with Claire McCann, her junior counsel, experts in the European Court of Human Rights procedures, and they're very arcane, believe me. You need the experts. And they're also expert sports laws. We've got the backing of the two Canadian friends, Carlos Sao and Jim Bunting. And that team is an expert team, but obviously, as Caster said, it all costs money. And I'm not sitting here begging you to pay my fees, because I'm not charging fees to Caster, and I never have. So it's not about that. It's about affording people overseas, and if you know anything, we all know about exchange rates. You can imagine what it is. And that is the third leg of the whole procedure. It's access to justice, and it's part of this thing that is going to be considered now. And when you talk about access to justice, when you've got one individual fighting world athletics with endless resources and endless powers and no support from anyone, and when you're fighting the state of Switzerland, you can imagine the power imbalance. And here we are having to ask for money to just get basic human rights and access to justice in a court which applies human rights. So thank you for listening to me. Please hold thumbs for 15 May. We really are hoping for the best, because they have taken it on as priority. They gave us an earlier date than you would otherwise expect, so they want to deal with the issue. And we're hoping that out of the 15, there will be at least 8 who want to find for justice and human rights. Thank you.
And Thank you, ladies and gentlemen. Thank you for making the time to come. And unlike my colleague from Norton Rose, I will try as much as possible to bring it home to all of us. My name is Caster Semenya. I'm the chairperson of the Commission for Gender Equality. Ourselves and Norton Rose have been on this journey as early as 2010 or so, somewhere around there. We are the custodians of certain sections of our constitution, one of which is section 9.3 of our constitution that says no one has the right to be discriminated against based on their race, gender, ethnicity, religion, sexual orientation, and a few other provisions. We also are a custodian of section 10 that says everyone has a right to human dignity in this country. But above all, we have a duty and a responsibility as an institution that has been set up by the Constitution to ensure that democracy is achieved. That provision is actually in section 7.2 of the Constitution that says the state must protect, promote, and respect. So I'm here at two levels. At the level of saying, we as the CGE and all of us here as partners would like to galvanize South Africa out there to be fully behind Caster Semenya, as the case says. It's very, very apt and shocking that here's a little girl, a young girl who came to Johannesburg to run from Limpopo, and a whole country, Switzerland, is taking her on. That is an indictment itself. But secondly, South Africa is a signatory to many provisions, one of which is CEDAW, Convention on the Elimination of Discrimination Against Women, and a whole others. If this is allowed, the implication is that we as South Africa are allowing other people out there to interpret our constitution for us. Our constitution is saying we are not going to discriminate. We do not want to discriminate. We have taken an intentional decision to write it down as supreme law. No one shall be discriminated. Here we are. We are part of a body that says, on second thought, that provision of yours, we are rendering it not applicable to us. But above all, we are rendering it not applicable to yourselves even, in the sense that as we continue to be a signatory of some of the international instruments, we therefore are confirming their power over the interpretation of our constitution. So this not only is it about Caster, yes, it is about Caster, but it is also about us standing fully behind Caster to actually stand up to the world and say, in my home, the interpretation is as follows. The tests and trials and tribulations that she has been put through have actually gone to the heart of human dignity, something that, again, we have signed and said everyone is entitled to. The physical examination and a whole lot of other setting aside of her rights have actually gone to her to question her dignity or even to take it away completely. So we as the CG are saying we are ready to take on and do our duty as that custodian, as that institution that is supposed to ensure that her human dignity is restored and stays intact. But we're appealing to all South Africans to see this for what it is, that we cannot have our constitution being interpreted outside to say, no, we are setting a bar that is lower. And to also start in our small little corners, asking ourselves, would this have come would this matter have come to this stage had it been a runner from another country, had it been an athlete from another country? The fundamental aspect of it is saying you are up there lower your standards to meet us. That's the implication of it. Should we be tolerating them? And therefore, I'm appealing to all of you to stand behind all of us as a partnership and as a collective that is going to fight this, but also to actually know that this is about Caster and a whole lot of other people out there who today are unable to enjoy the benefits of our Constitution. Thank you.
Good morning, ladies and gentlemen. My name is Shafiq Amelia. I'm the National Director of ProBono.org, and we have a national current footprint in South Africa as well. And I'm here particularly, and as you can see, I'm sitting on the fringes of the setup here, primarily because Pro Bono deals with vulnerable people and their rights that are abused all the time. Ladies and gentlemen, being able to access justice is a basic human right. To the Caster Semenya Foundation, chairperson of the CGE, as our constitutional Chapter 9 body, colleagues, friends, ladies and gentlemen, all protocol observed. It is indeed a momentous occasion for us to be here to witness one of the most gross violations of human rights that is playing itself out in what Mr. Brecher has said, the imbalance of power that is confronting us and that Caster Semenya is being challenged with. So on behalf of ProBono.org, it is a pleasure to be here. The late President Nelson Mandela stated, "Sport has the power to change the world. It speaks to youth in a language they understand. It has the power to inspire. It has the power to unite people in a way that little else does. It speaks to youth in a language they understand. Sports can create hope where once there was only despair. It is more powerful than government in breaking down racial barriers. Indeed, sport can be a unifier, a tool that can be used to unite across race, creed, color, religion, and inculcate shared values of diversity, equality, tolerance, and fairness. The Sustainable Development Agenda, the UN Sustainable Development Agenda, highlights the importance of sport as an enabler of peace and development. However, we know too well that sport does have negative outcomes. We know of instances where athletes have faced human rights violations at the hands of sporting federations, as we see today. The United Nations Human Rights Council has on occasion expressed concern on discriminatory regulations, rules, and practices that may require women and girl athletes with differences of sex development, androgen sensitivity, and levels of testosterone to medically reduce their blood testosterone levels. The United Nations Human Rights Council noted that such discriminatory regulations do contravene international human rights norms and standards, including the right to equality and non-discrimination, the right to highest attainable standards of physical and mental health, the right to sexual and reproductive health, the right to work and to the enjoyment of just and favorable conditions of work, the right to privacy, the right to freedom from torture and other cruel, inhuman, or degrading treatment and harmful practices, and full respect for the dignity, bodily integrity, and bodily autonomy of persons. Ladies and gentlemen, colleagues, the resilience of Mohali Caster Semenya in fighting against discriminatory regulations by the World Athletics Federation has to be commended. If we were to ask Caster Semenya today, was it all worth it? And I'd like to reflect on something that I read just before I came here. In his memoirs, Ibrahim, in his biography, Beyond Fear, Reflections of a Freedom Fighter, on page 284, was also asked the same question: was it all worth it? And the following that he said there leaves us with the following food for thought. The late struggle stalwart of struggle freedom in our country had said, one of my favorite quotes is from the great writer Nikolai Ostrovsky. I have tried to live my life by this creed. Man's dearest possession is life. It is given to him but once, and he may live it so as to feel no torturing regret for wasted years. Never know the burning shame of a mean and petty past. So live that, die he might say. All my strength was given to the finest cause in the world, the fight for liberation of mankind. And in Caster's case, the right to live in dignity and say no to any form of injustice. ProBono.org is excited to join the fray and be counted among the entities and organizations locally and globally that continue to galvanize effort and support the ultimate repeal of discriminatory policies and practices which continue to reinforce unfair discrimination in sports. To Caster Semenya, we wish, and our prayers are, that you will be successful in the upcoming litigation before the Grand Chamber of European Court of Human Rights. As espoused in our Bill of Rights, your right to stand up for dignity and say no. As Patrick said, this matter is set down in Strasbourg, in France on the 15th of May, 2024. And let us reassure you, Caster, that you're not alone in this matter. You have all our love and support in your quest to live a life of dignity, and we salute you for the stand you have taken. On behalf of Pro Bono, I say thank you very much.
Good morning, everybody. It leaves me to wind up the session today and to thank you all very much for being here on behalf of Caster. At the end of the day, it is all about Caster and how she stood against prejudice, discrimination, and the like. I've jotted a few words down here because I've known Caster since 2009, since Caster was 18 years old. We've traveled a long way, and this is a particular moment in history where we want the nation to rally behind her, not only in words, but in deed as well. Patrick has spoken about the great expense of how these courts are situated in some of the wealthiest cities in the world, and our access to justice is denied just for that reason alone. We've heard from other speakers about how this access is denied, and it has been denied to Caster. But one thing I can assure you, that throughout her illustrious career, Caster has shown tenacity, she's shown courage, and she has shown unrelenting fight against injustices. When I asked her, are you ready to fight in the European Union? She said without hesitation that she was. That she said something extraordinary. She said, I'm prepared to fight for myself, but for others that follow me. So Caster's fight is not only about Caster, it's also about those athletes that follow Caster and who treat her as the role model that she is. So, ladies and gentlemen, it's my privilege to be here today, as I said, but also my rallying call to you to be on the precipice now, as we are on the side of Caster, to be proud to be with her, to rally behind her, and if I may be as crude as to ask for the financial support that Caster needs to see through the fight. It's no small expense, as Patrick outlined. We have been doing it for pro bono for many years, and I've done it since 2009. But the King's Council in London and the experts that we have carry a cost with it. So our appeal to you, to the public, to South Africans and to global citizens around the world is to put your money your hands in the pockets to please assist us as well. So thank you very much, ladies and gentlemen. Please be a rallying call, get behind Caster, get under her wings, lift her to the highest mountains, and we can do it together. Thank you very much for all being here. And may I also just in passing, not in passing, but I should just say thank you very much to Kat for organising it, to the Munia Resources for bringing us together, and for all of you to make the time today to be here. We are greatly grateful. Thank you very much.
Ladies and gentlemen, thank you very much. We're not alone in this journey. We have got Ritono here, we have got Debuho, we have got Kat, we have got Becky, Tristan, and other members of the team that work tirelessly to make sure that today's briefing, it's all about Caster. You might have seen something similar from the colleagues and learned friends. All of them, I think they are advocates and lawyers, all of them, including our chairperson, is advocate in Mokano. They were so serious about this matter. We make a clear call as this body of institution to look at the dream being deferred of a young child from my province, Limpopo, who has taken over the world by storm, and they are running and surpassing every human expectation. It's the injustice that she's suffering today. The violation of rights because of who she is and what she's making everybody to eat the dust behind her. I'll ask I'll take few questions. I know all of you. You'll want to talk to them. We'll make arrangements to talk to Caster also. But please do ask this body of people who are.
All right, we come out of that media briefing, of course, various stakeholders, including Chapter 9 bodies and legal representatives, briefing the media there ahead of the upcoming case at the European Court of Human Rights. And of course, just pledging and expressing their solidarity with Olympic champion Caster Semenya there. Of course, she also spoke a little bit earlier on. And of course, that date of the court has been announced as the 15th of May. She says this is about human rights. She's also said that this is about building an African girl and that her task is now to advocate for those who are silent. Just a reminder that this case was referred by the Swiss government against on the 9th, in fact, in July 2023 judgment of the European Court of Human Rights, the world athletics body. And of course, it is bound by international law and may not discriminate against anyone without compelling reasons. And those were the reasons that were given.